Now we continue with the second remedies. Private law remedies, also known as equitable remedies. This is also called as non-prerogative writs. Can be divided into two: injunction and declarations. First, we start with an injunction. Injunction means an order. Sorry, an order to restrain an administrative authority from an unlawful or ultra-vires exercise of its power. Injunction also means to stop. It is a preventive measure to restrain a person from doing a wrongful act. We notice that the public authority is doing wrongful act, so we may apply for injunction in order to restrain him from continue his action. This is based on section 50 to section 55 of the Specific Relief Act 1950. And then section 50 of the Specific Relief Act 1950 provides that preventive relief can be granted at the discretion of the court, either by temporary or perpetual injunction. First injunction known as a temporary injunction. This is also called as interlocutory or interim injunctions. This is based on section 51 subsection 1 of the Specific Relief Act 1950. The purpose of temporary injunction. Temporary means dia hanya bersifat sementara. So to maintain the status quo. Status quo is the present condition, situation sekarang lah. Pending hearing of the suit and final determination of the issue. This is before the decision made by the court. So it can be granted at parte. Parte means together and at any stage of a suit. Based on the case of American Senate against Atticon Unlimited, there are two conditions that must be satisfied by the court in order to grant a temporary injunction. First, there must be a serious case to be heard. The case must not a frivolous and vexatious. In other words, case tu bukanlah satu case yang remeh-temeh. And then second, if there is evidence to show that the plaintiff has a good prospect of securing the permanent injunctions at the end of the trial. Second condition is when the court noticed that the plaintiff may successfully claim for a permanent injunction, so court also will grant temporary injunction against him. Next. Types of injunctions. The second one is a perpetual injunction. Perpetual also means permanent injunction. Based on section 51, subsection 2, the defendant is perpetually restrained from exerting a right or from continuing an act which would be contrary to the rights of the plaintiff. Perpetually restrained means that permanently restrained, forever. Under section 52, subsection 1, it may be granted to prevent the breach of an obligation existing in the favor of the applicants. When we notice that the authority is going to breach of his obligation, so we can apply for this injunction. Section 53 states that if it is necessary to compel the performance of certain acts in order to prevent the breach of an obligation, the court may, in its discretion, grant this injunction. And there are various situations where injunction will not be granted by court. For example, based on section 54, subsection D, court will not interfere with the public duties of any government's department in Malaysia. Under subsection E, to stay proceedings in any criminal matter. Normally we focus perpetual injunction for civil matters. Under subsection F, when an equally efficacious relief can certainly be obtained by any other usual mode of proceedings. When the applicants can apply for adequate relief. So he may not apply for permanent injunction. And under subsection J, when the conduct of the applicants or his agent has been such as to disentitle him to the existence of the court, means that he is not entitled to claim for perpetual injunction. Okay, third, known as a Mareva injunctions, the purpose is to freeze all the defendant's property before it could be disposed of from the date the writ was issued until judgment made by the court. Okay, this is based on the case of Mareva Companies Marira SA against International Bulk Carrier SA. And this type of injunction also based on section 25 of the Core of Judicature Act and read together with section 50 and 51 of the Specific Relief Act 1950. So in order to claim, to apply for these Mareva injunctions, okay, we can claim from High Court. Okay, next known as Anton Appellate injunctions. This is to stop the defendant from destroying any important materials that may be the cause of the suit is filed. Okay, so if we notice that the defendant will destroy the important materials, important evidence, okay, so can apply for Anton Pillar injunction. This is also based on the case of Anton Pillar KG against Manufacturing Process Limited. And the last one known as Erin Ford Properties Injunctions, and this injunction is to secure an interim injunction which is refused earlier, so he could still be granted Erin Ford Properties Injunctions pending appeal against the refusal of the interim injunctions. This is where, okay, the applicant already applied for interim injunction but has been refused by court, so pending appeal, okay, he may apply this injunction, okay, based on the case of Erin Ford Properties Limited against a Shire County Council. Okay, and the next private law remedy known as a declaration. Okay, declaration means to declare the rights, okay, the legal rights of a persons. Okay, this is can be exercised by the applicant if there is no other remedies available to him. This is based on section 41 of the Specific Relief Act 1950. So it does not make an administrator being forced into doing the declaratory rights. Okay, this is not similar with mandamus. Okay, and it also not quash or cancel any action taken by the administrator. But okay, a person who has local standard may apply for declaration if there is no alternative remedy available. So he must has interest in order to apply this remedy. So the idea of seeking this order of declaration is based on the reasoning that a public authority will not disobey the law once it is discovered what the law is. So it may effectively weaken the enforceability of an administrative actions. Okay, so impliedly it will weaken, okay, the enforceability of the administrative actions. Okay, as for example, you may refer to the case of Tan Pui Yi against a Ketua Pengarah Jabatan Pendaftaran Negara. In this case, the court granted declaration saying that medical evidence presented in this case individually, collectively, and ambiguously concluded that the plaintiff was a male. Following that, the defendant be directed to change the plaintiff identity card to Tan Yen Ho, and in addition, the defendant be directed to change the last digit of the plaintiff identity card to a digit that reflects the male gender. So in this case, the court granted declaration against the to the applicants. Okay. Okay, another example where you may apply this type of remedy is if a local authority, for example, if a local authority issue an order to Makkiyah to pay certain tax, and if Makkiyah succeeded in seeking a declaration saying that the authority has no power to do so, then Makkiyah does not has to pay for the tax. This is to prove that, okay, you want to sort the declarations, okay, legal rights of a persons. Okay, that's all about the public law remedies. Okay, I hope that you all clear on this topic, remedies under administrative law. Okay, because this is a part of your assessment letter. Okay, thank you. If you have any question, then you may ask me directly. Thank you, everyone. Assalamualaikum.